report on sex offender registration laws in Alaska and Connecticut.
Supporting the full implementation of Megan's Law, sex offender registration and notification. We are really optimistic about today's arguments and feel very strongly that the government will continue to exercise its right to provide valuable information to the community to help parents and community members protect themselves from those individuals they know pose a risk to public safety.
Ms. Ahearn, what about the concern expressed by some of the justices here that the law sweeps very broadly, that it includes people who have had minor offenses, and that they're all kind of lumped in together, and that it gives a misleading impression of at least some of the people on the list?
What we have to do when we are reasoning sex offender registration and notification is we have to look at it from two perspectives, the victim and the offender. And when you look at it from a victim perspective, when a sex crime is committed against a child or a sexually violent offense against an adult, we're talking about a lifelong devastating impact. And knowing that sex offenders have high rates of recidivism, knowing that these are individuals that more than likely will spend little or no time in jail, and compared to, say, like a murderer who goes to jail for an extended period of time, these are individuals that we know are posing a high risk of public safety. So we have to consider that, and we have to consider the lifelong impact to a victim when we reason out why we're actually doing registration and notification.
But some of the people on there did not have children, were not their victims. Some of the people on the list.
Well, one of the things that I heard one of the attorneys say is that there are family members who do not want information published on the internet or anywhere else because they have concern that victims will be identified. Victims are never identified as part of notification procedures and registration. The information is not available. And while that may be true, that offender may not want the information available, we know that 90% of sex crimes are committed against people that offenders have established relationships with. So children are being molested by those who they know very well. And of those offenders, about 1/3 are committed by family members. But that third who commit crimes against family members, half of them will commit crimes against individuals that are outside of their family. And we're not just talking about children, we're talking about sex offenders that are what's called situational molesters. They will molest not because they're pedophiles, but just because they have an opportunity to molest. So they'll target children and adults.
Okay, but what about the question that the list is too inclusive, that it sweeps too broadly, that it includes people who have never targeted children and have done misdemeanor offenses?
What the list will include, according to Wetterling guidelines, is individuals who commit sex crimes against children and sexually violent offenses against adults. So if there are people that are mistakenly put on the list, then I would take that up with the individual state. But we have to include those individuals who, knowing what the statutes are in their state, commit crimes against those individuals they know they shouldn't be having sexual relationships with. We can't make moral decisions, but each legislature makes a decision based upon the values of the individuals in their state, where they're going to set the line. A minor is a certain age, and knowing that, an individual who engages in a relationship with a person must know. And if that means you're going to check their license, you should, because you want to protect yourself.
Thank you. Thanks very much.
Sure.
Appreciate it.